Hello, everyone, and welcome to another episode of the Big Questions with Big John. I'm your host, Big John, and we have a very special guest with us today, someone who obviously loves dogs. Let me introduce our guest here. I'm being joined by Stephan Kinsella. He is an American writer, speaker, intellectual property attorney, and an ANCAP. That's right, an anarcho-capitalist philosopher, very specifically. He is the founder and director of the Center for Study of Innovative Freedom, and he is here today to talk to us a little bit about IP law, how it ties into libertarianism. Maybe we'll get him to talk a little bit about the philosophy of being an ANCAP. And you may have recognized his name from a book that he's very famous for. It's called Against Intellectual Property. Ladies and gentlemen, welcome Stephan Kinsella. How you doing today, Stephan?
I'm doing well.
Okay, good. I'm glad to hear that. Yes. It's very interesting that when I first heard about against intellectual property and some of the premises it put forth, I have to admit that as a libertarian myself, I found it a little bit contradictory in my own head. Right. So I would love to get a little background on you and how, you got into law, how you got into anarcho-capitalism as a philosophy, and then we could migrate specifically to IP law and your views of it.
Sure.
But why don't we start out with that? Like, tell me a little bit about your background, your history.
Yeah, it all ties in together. And yeah, I'm more known in libertarian circles for that against intellectual property work. But this is my recent book just came out.
There you go.
Late last year.
Legal Foundations of a Free Society. We'll put that up in our Chiron so people can know to look for it.
And there's a big section on intellectual property in there. But I'm an engineer by background, electrical engineering in college. But then I decided to go to law school to, I heard you could make more money at it, and I was good. I was starting to argue a lot because I was into libertarianism as well in college and in law school. So I studied law, and I loved being a lawyer. I actually enjoyed it a lot. And I never did join the professional, like, libertarian career thing, like working at Mises or working at Cato or something like that, although I've had overtures and kind of offers in that regard. But I always wanted to have a private career that was just my career. And then use that to fund my hobbies, which was libertarianism. But I've been writing the whole time on libertarian topics as well, probably to my detriment in a sense. I'm basically retired right now. In the beginning, no one paid it. In the beginning, when I started writing things critical of intellectual property, even though I was practicing as a patent attorney at the time, I was a little bit worried that my clients or my law firm might find out about it and get upset with me. Right. But you finally realize you're not that important, and people they don't really care what your religion is or what your sexual preferences or your taste in food or whatever your hobby. They don't really care. And in fact, I found over time that as I became more and more notorious and voluble about speaking out about my views on IP, I got clients because of it. Someone would say, "Oh, that's a great talk you just did about why the patent system should be abolished. Hey, I've got an invention. Could you help me patent it?" Because I think they assume that if you have such an articulate opinion on something, you must know a lot about it, which is true. I mean, I was a good patent attorney. So it actually didn't hurt my career. Although I do think that, like, I'm basically in retirement now, as I said. If I wanted to go get a job at a big law firm now, they might Google me and find a lot of libertarian, anarchist, and anti-IP stuff, and they might be confused by it. It could be a hindrance.
I was going to say it's interesting because you said you kind of joked, and I'm not quite retired yet, but we're probably of the same generational bound. Like I would assume a Gen Xer, perhaps maybe the tail end of the boomers for you.
I was born in '65, so I'm the first Gen X, I think.
So am I. So we're the same age, same age. So the first of the Gen Xers. And yes, I agree with you that maybe coming up, I came up on Wall Street, sort of similar to you. My undergraduate degrees were in biology and computer science. I somehow ended up on Wall Street. But I agree with you that back then you could be a little bit freer about your moonlighting. But it's interesting that you mentioned that, and I'm sure some people in the audience, like say the younger generations today, might say, "What do you mean you weren't canceled? Isn't that a big thing going on today? That people are being vilified or penalized for their opinions?"
Well, the thing is, I mean, I've spoken. Like, I just spoke at Lewis and Clark College in Portland. Mm-hmm. I've spoken at Berkeley. I've spoken twice at Yale, and usually on IP, not always. I think almost all 4 times are intellectual property. And I was never picketed or canceled, and I was a little bit offended. It's like the reason is because I'm an old white guy, but I'm talking about something no one knows to be offended about. Like, I mean, my anti-IP views are not mainstream, and they imply anarchism, but they don't sound racist, or they don't sound like an old white guy. I mean, like, it's totally different. In fact, at the Lewis and Clark debate, I was debating a younger, hip European guy from Belgium, and our debate topic was about whether Western American style intellectual property international laws are a type of imperialism that harms the developing world, the third world. And I was arguing, yes, it is. So I was the old white guy in the room, but I was arguing in defense of the developing world, but I was doing it from a pro-libertarian capitalist property rights perspective, where there's this hip young guy who was defending international IP. And, so like the audience wanted to be on my side, but I don't think they understood. They couldn't quite wrap their heads around the messenger of this message and the reason, but they listened and they liked it. So I found it quite interesting and worth doing and gratifying.
Yeah, and that sounds like a weird position to put, that some of these people who reflexively will react to, like you said, an old white dude. Yeah. And then all of a sudden here you are arguing for developing countries, for the third world,
but using pro-property rights, pro-capitalist reasoning to explain what we're doing is wrong. So your question though, and I talk about this in the book, I have a little biographical stuff, but so I switched to law school for various personal reasons, and I liked it. I did well in it. I was an oil and gas attorney at first, and then I switched to intellectual property and patent law, and had a long career in that at law firms, and then in-house as general counsel to a high-tech laser company for about 10 years. And then I did my own practice for a while, and now I'm basically just doing a few little things, but I'm basically retired. But the whole time I was publishing and had this side thing, this avocation, I call it, to distinguish from my vocation, which was going to the Mises Institute, reading about Austrian economics and libertarian theory, and writing where I could. I mean, my main interest always was rights theory. Like, how do we justify the rights that we have? I was originally a Randian, like more of objectivist oriented, and I still have lots of influences. But my main influence now, I think, would be, honestly, probably Hoppe, Rothbard, and Mises. Mises, especially on economics and his methodology, and then Rothbard on his radical political stuff, and then Hoppe on sort of synthesizing all this and his integration of the two and his emphasis on scarcity. And so when I started practicing IP law, I decided to switch from oil and gas to patent law in 1993 or 4, so I could move out of Texas to Philadelphia for my wife's career, because oil and gas law is not it's not a national field, but it's a state-based thing, like Louisiana, Texas, Oklahoma, maybe. But patent law is a federal field, like antitrust law and tax law and other things. So I switched to patent law, partly just to be geographically mobile. But when I did it, I started thinking, I had always been uneasy as a young libertarian with the arguments for patent and copyright law, like that Ayn Rand made. They always made no sense to me. Like everything else they said made sense. I mean, rights, aggression, proportionality, property rights, but the arguments for IP made no sense to me because it's like they last for 17 years or another amount of time for copyright. How can you justify a system where there's rights but they only last for a limited time?
Yeah. And that's
so
interesting.
That's what always bugged me. So I figured if I'm going to practice IP law and if I'm going to be a libertarian writer and theorist, I need to figure this thing out. And so I embarked upon a quest for 3 or 4 or 5 years. I thought I'm going to be the guy that will justify IP because no one else does a good job of it. I'll do it because I'm the only one who can because this is a hard field. And I kept coming up with blanks. I was like, all my arguments didn't work. They all were as faulty as the ones I had been criticizing before. And finally, when I turned my head around and I thought, well, what's a possible reason why Kinsella can't figure out how to justify IP? Is it because I'm too stupid? Or is it because maybe I'm trying to justify the unjustifiable? And once I had that realization and I said, okay, let's assume IP is not valid, and it all fell into place. And then my views on scarcity and property rights and individual rights and the law, it all just made so much more sense. And so IP to me is not a linchpin issue, but it is something where once you see it, it's actually not that hard to understand, I think. It's hard to get over your aversion to it. I remember my friend Jeff Tucker, who said something very similar to what you said in the beginning. Jeff was at the Mises Institute when I published my paper on IP, and he was like kind of dismayed that they published that piece because he thought I was crazy. And he didn't understand why the Hans Hoppe and the Journal of Libertarian Studies would publish my article, and he thought I was crazy. But then he read it again, and I read it again, and then he became like the Engels to my Marx, as he calls it. He became totally persuaded. But once you sort of see it a certain way, then a lot of things become clear. So,
sure.
Anyway.
Yeah. No, that's an interesting story. But I want to also sort of like take a pause here because for people watching, like I try to reach all sorts of libertarians, people interested in libertarianism. Right. So this isn't like I know sometimes if you watch, like, say, someone like Dave Smith talk about, you'll get into a deep dive, heavy philosophical intertwines. And I want to pull back a little bit. So most people would associate with libertarianism individual rights, property rights, very surface on the very top level sort of understanding. And it's interesting to me, and, like just in reading generally, not every libertarian agrees with your anti-IP position, right? There's some objections. But before we even delve into those, talk to me a little bit about anarcho-capitalism. First of all, define it for me in your view, and then compare it, say, to other, quote, flavors of libertarianism that may or may not fall in line with what we're going to talk about in terms of anti-IP rights. For example, ANCAPs, agorists, minarchists,
voluntarists,
flat-out anarchists. I think this confuses a lot of people, especially anarchy. It's a scary word. It's been portrayed scarily. We think of Somali pirates when we think of anarchy. So if you don't mind, let's take half a step back.
Sure.
Explain to me, explain to the audience, anarcho-capitalism as a philosophy and as a practical system in a stateless society.
Well, let me try to go maybe a little bit chronologically with the way I came to these views. So originally I was like nothing. I was just a 10th grader and I didn't know anything about politics. And then someone said, my librarian said, you should read The Fountainhead. So I read Ayn Rand. That opened up a world to me of I was always into science, but now I'm like, oh, philosophy is interesting too, right? There's political ethics, and then so I was originally like an objectivist who believed in reason and in non-aggression, let's say, in property rights. But I believed initially, I believe she was correct when she condemned anarchy because she was more of a minarchist, and she even condemned libertarianism. She said it was a hijacking of her philosophy. So I initially steered clear of anarchists and libertarians because I thought she was probably right, because that's what she said, and she was right about other things. So, but finally, in college, I started reading Rothbard and Misesians and other libertarians, and eventually read the Tannehills, who are classic libertarians. And back in those days, so I think you can distinguish the libertarian movement as being, okay, there's different ways to distinguish it. You can have pragmatists and principle types. You could have minarchists who believe in a small state but not no state, or anarchists who believe in zero state. And they used to be called Anarcho-Capitalist. I don't use that term anymore. I usually say Anarcho-Libertarian because capitalist, well, it used to be a pejorative anyway, but you don't really need to be in favor of big business capitalism to be an anarchist libertarian. Like, there are left libertarian anarchists, right, who have their own preferences. So I say anarchist libertarian. I do think that we should include in the label of libertarian as a concept minarchists and anarchists, even though I believe minarchists are, a better term would be mini-statist. Like, they actually prefer some states. So they're kind of a statist, but they're not a big time statist. And it's not really an insult. It's just descriptive, but I'm willing to include them as a type of libertarian. I would disagree with, like, my friend Jeff Tucker, who uses the term liberal now, and he doesn't like to use the word libertarian because the libertarian movement, in terms of the party and some of the movement and the activist types, has become embarrassing in some ways. So he likes to distance himself, and he calls himself a liberal and says, "Oh, libertarianism isn't a new thing. It's thousands of years old. It's called liberalism." And I'm like, well, I think classical liberalism is one of the precursors to the modern libertarian movement.
Yes.
My view is the modern libertarian movement started with, like, Ayn Rand and Leonard Read in the 50s and 60s. I think that's what modern libertarianism is, when we had this kind of focus on individual rights and property rights and an obsessive, almost autistic or OCD zeal for consistency, which is why I think some of us are libertarians. We're obsessed with consistency, which I think is a good thing, but you can take it a little bit too far if you become too rationalist or too deductivist or whatever. And so, I was a minarchist Randian for a while, then I became more libertarian, and then finally I realized that all the arguments against the state are good, and that all Rand's arguments for the state were bad. So I became an anarchist, say, following David Friedman and the Tannehills and Murray Rothbard and people like that. So to me, an anarcho-capitalist is, but this is what's different. So I haven't written a lot on anarcho-capitalism because it's like when people ask me, when I say, well, we should abolish the patent system, then their question is, well, how am I supposed to earn a living, doing this? It's like, it's a weird jump in their questioning. Like, they want me to answer some kind of demand they have. But it's as if they're thinking that I am promoting a system and I have to give you the outlines of the system before you can accept it, which is the same thing with anarchy. So as an anarchist, I'm not promoting a system or telling you how it would work. I mean, we have some guesses, we have some ideas about what would probably happen, but it's like if I opposed, child enslavement or child rape, and you said, well, what's the replacement for that going to be? It's like, well, I don't know, but I'm against child rape. Or if I was opposing slavery back in the antebellum South in America in 1821 or 1840, and someone said, okay, that's all well and good that you're proposing that we abolish slavery, but in your system, who's going to pick the cotton? And it's like, well, I don't know, but the fact that I don't know who's going to pick the cotton doesn't mean that slavery is justified. So to me, the question's always upon the justice of an issue, and whatever happens in a free society in response to getting rid of an injustice, might be interesting to see, but it's not incumbent upon me to, like I tell people sometimes, they say, well, in your system, there's no copyright. How can I make money off writing my novel or my book of poetry? And I'm like, well, your failed business model is not my problem. I was like, you've got to take justice and morality and legality and economic real world conditions into account when you come up with an idea about how to use the time in this world. And if part of that is you want to make money on your hobby, you got to figure it out. I don't know. But the answer is not we should impose from the top down an immoral and unjust system that violates people's property rights, like patent and copyright.
Well, that's an interesting, and listening, and thank you for that formulation, by the way. I think it makes things a lot clearer, both to myself and to the viewers. So if I can sort of maybe engage a little bit here, like, to your point, I'm probably what you would call a minarchist in my own philosophy and beliefs. And part of my reasoning for that is that if I could somehow magically start society from scratch, I would probably be an anarchist. I'd probably be a 100% voluntarist, like no coercions, no states at all. But given the point we're at, if we can agree to form our society, stateless society, it doesn't prevent others, or it doesn't encourage others to follow the same. And I think it is a rightful position for someone to say, not how can I make a living, but how can I stay alive? How can I ensure that my life, not ensure, but how can I, is it preferable to me in terms of self-interest to be part of a society that, say, won't protect me against aggression, for example, from an aggressive state. So I understand that. I mean, I understand the anarchist position, and I certainly respect it. I don't know if I myself am willing to take that final leap. That's why I kind of consider myself a minarchist. But
let me say something. So, like I was saying, there's people like David Friedman, Hans Hermann Hoppe, Bob Murphy, others who have written in detail about how they think an anarchist society would work. I've never really done that. My kind of key writing on anarchy is to say, I think it's chapter 2 or 3 in my book. I think it's chapter 3 in my book, what it means to be an anarcho-capitalist. And like I said, I would now probably say anarcho-libertarian. But what it simply means, it's not a prediction or a prescription or a plan. It's simply recognizing two things. Number one, the essence of libertarianism is property rights, individual rights, which are property rights, which implies the non-aggression principle. They're all bound up together. So it's an opposition to aggression defined in terms of violating people's property rights. And number two, recognizing that the nature of the state, what the state is, that it necessarily by its nature commits aggression. So if you're against aggression, then you have to condemn the state and recognize that it's a criminal organization. That's to me all that anarchism is. It's recognizing the state's criminal and unjustified nature. And then you'll get these responses like, well, but the state's necessary, or the state is inevitable. It's like, well, first of all, how does the state being necessary justify what it does? I mean, I just explained to you why we're all against aggression and why the state commits aggression. So if you disagree with me, you have to either say you're not against aggression all the time, or you have to say that the state doesn't necessarily need to commit aggression, which are very hard to argue. Now, a respectable argument, I think, an intermediate argument would be like what I call sort of like rights utilitarianism, like a blend of those two ideas. It would be saying this, like we all want a world where rights are not violated, but it's not possible to have the world because people have free will, and there's no God up there with space lasers that stops everyone from preventing a crime
right
at the moment of the crime, and there's no invulnerability suits. So crime is always going to be a possibility, and it will probably always happen, but we can still oppose it, right? But we want to minimize it. So how do we minimize it? We minimize it, number one, by not committing it ourselves and by living in societies that try to promote these values, and by having social norms and institutions and laws that try to prevent or retaliate or whatever against people that are the outliers, the outlaws, right? So that's the purpose of law, is to try to reduce. So I could see a respectable person saying, listen, I would prefer a utopian world with no states and no aggression, but given human nature and the social nature of our species and the fact that even if you had this world of 100% doe-eyed hippies that never hurt each other and that are prosperous and they don't need a state and all this, in that kind of world, the incentive for one person to be the defect, to the cheat, because you can go to your neighbor's houses because they don't have their door, they don't have locks on their doors because they don't, you can rob people so easily. It's gonna happen. Like, this is economic reality. It's game theory, right? It's going to happen. And so you have to recognize it's going to happen. So you want to minimize it. So I could respect someone who says, listen, I would love your anarchist world, your anarchist libertarian world. But in reality right now, we have to choose between A and B. And I want to choose the one that has less rights violations. And I think if we had a minarchist state, it would violate rights by taxing people and outlawing competition and by having an occasional bad law and excesses and all this. That's still better than a chaotic world where the private crime that would happen would be even worse. I can totally respect that argument, but that's almost never the argument. I mean, maybe that's a Hobbesian argument to a degree, but it's almost never, but he wasn't a minarchist either, right? So it's almost never the argument anyone makes.
It's my argument. That's actually exactly you've just outlined my argument. Yeah. Exactly. Yeah. Yeah.
So like I'm saying, and this is why, by the way, unlike some anarchists, they would say minarchists they're not libertarians.
Right.
No,
exactly.
Libertarianism is broad enough to include minarchists. I just think most minarchists are not fully consistent. If you really oppose aggression, you have to oppose aggression. If you personally can't see a way to have everything you want, and you're like frustrated, and you're like, well, I would love there to be no aggression, but I can't get that. So I want to let this one little group, the state, have some powers, very carefully circumscribed and controlled by checks and balances in the Constitution and the democratic process or whatever, and then they can stop even greater harms. I actually respect that perspective.
Yeah. No, that's fair enough, because I think that's where I find myself a lot, and personally, is that hey, as I live my daily life, my whole goal is you leave me alone, I'll leave you alone, and we'll just pursue our own self-interests as a matter of my personal conduct. But I do think there is that sort of are you willing? Negative rights, an enforcer of negative rights gets tossed around a lot. I don't know if that's the right word or not, but I do see that as to me personally as something that I'm willing to do, at least. But I certainly do not find fault with someone who considers himself an anarcho-libertarian, as you put it.
By the way, you mentioned negative rights. That's something I've written. I've touched on a lot of these things. Most of them are mentioned in my book, but a lot of libertarians will characterize our philosophy as saying, "Oh, we only believe in negative rights, no positive rights," and I think they're trying to do that to say that it's okay to have a law that prevents you from hurting someone else, but it's not okay to have a law that forces you to pay taxes to provide welfare or housing or education or whatever for other people. But to be precise, and I found this in my long career of writing and all this, that it's really important sometimes to get precise with language, because otherwise there will be confusion or equivocation or talking past each other. Libertarianism, even in my anarchist version, does not prohibit positive obligations or positive duties. It simply prohibits unchosen ones. That's it. So, and the example I've given for a long time is that even the common law has long said, the regular private law of the Western world has said that there's no positive duty to rescue someone, right? Like if I'm walking by a lake and there's someone drowning, yeah, maybe morally as a good person, I should dive in and try to rescue them. And I actually believe that's true. You should morally try to rescue people and help them. But that's a personal moral belief. It's not about political interpersonal ethics and law. And the law says, well, no, I mean, if the guy drowns, you can't be charged with manslaughter or negligence or murder or homicide because you didn't do it. Like there's no legal positive obligation to do that, which I think is correct. However, if I'm the guy that pushed the guy into the lake, like, you know, I'm at a party with some people and there's a guy that doesn't know how to swim and I just like push him into the lake as a prank. I actually now do have a positive obligation to try to save him because I'm the one who caused him to be in the business of peril. And the analogous argument that I've made is that I think parents have obligations to their children. I mean, you brought a helpless, dependent person into the world. It's very analogous to a drowning guy in a lake who can't swim. Babies don't know how to do anything. They can't. They're physically, physiologically, and sociologically dependent upon their parents. You caused them to come into this world having these needs. You better take care of your goddamn children. You know what I mean? Like so, and so I have no problem with positive obligations as long as they're the result of your voluntary conduct or something that you undertook. So I think libertarianism is simply against unchosen obligations.
And that makes sense to me, the way you frame that. It absolutely does. And it's also, I think, why a lot of us had an uneasiness to those Good Samaritan laws that seemed to be passed locally in the 90s. I think it was in the 90s. Well, famously, it was featured in that final Seinfeld episode, right? They all went to jail for failing to execute the Good Samaritan law.
Oh, I forgot that was part of that.
Yeah.
What were the Good Samaritan laws? Were they
like if you see someone in particular distress that you had an obligation to help them out if it didn't cause you distress.
Okay.
You know, for example, it might be someone laying in the street with a broken leg saying, "Help me." Call 911 or something like that, and you saw them, you had a cell phone, and you walked by them without taking any action to help them, you would be in violation of a quote Good Samaritan law.
I am unaware of that. I will tell you that of all the laws that I would, if I was the dictator of the world and I could start repealing laws, that would not be the first on my list of things to repeal. That kind of law is, probably technically it's not justified, but it's not the worst law in the world, right? I
think it's okay because I think you and I might share a certain moral framework where we would stop and do whatever we could at that moment. And I think, speaking for myself at least, I have been placed in those situations, and without second thought, I've been, let me help this person.
There's sort of there's actually arguments you could make that sort of justify these laws. I mean, I don't think that legislation is the way to make law anyway, which is chapter 13 in my book. But I think that the basic idea of a contextual assumption of an obligation can make sense. So, I could see an argument. For example, in the law that has long held that you have no duty to rescue someone, okay?
Right.
But there's exceptional cases where, so let's say there's a guy drowning at the beach,
right? And
there's a bunch of people, a bunch of onlookers in the crowd, and one guy jumps in the water and starts swimming toward the guy to try to rescue him. Now he's taken on a legal obligation because if he gives up halfway through, then the guy will drown. And the reason he drowns is because there's no other rescuers coming. And there's no other rescuers coming because they saw that I was doing it. So it's like it's highly contextual. And so I could see an argument made that in a highly dense city like, I don't know, New York or somewhere, everyone sort of or even take other examples where you hear about these stupid the daredevil types that, they go
Right.
skiing off the top of a mountain.
Right.
They're assuming that there's helicopter teams waiting to rescue them. I mean, they wouldn't do it if they knew there was no support system there, but the support system is there. So they take that into account in their calculations. Right. So if the rescue team is negligent in rescuing him, then, you could make an argument. Like, the whole thing is heavily, heavily dependent upon context. But my point is this: like, if I was eliminating laws, I would start with probably the Federal Reserve, public schools, intellectual property, taxation, welfare.
So this is on the list, but very low on the list.
Okay, it'd be really low on the list, and it's so low on the list, and it's partly low because you could imagine something. You could imagine some private version of that emerging in a totally free society where you live in a community where there's, I don't know, an agreement among your insurance providers, or there's an HOA rule which says, yeah, if you can rescue someone at very low cost to yourself that's in a dire emergency, you got to do it. And if you don't, you're in big trouble. I think that could emerge, right? I mean, you could see it emerging as a moral norm. I can see it emerging as a quasi-legal norm too. And so having a state law that says something like that doesn't bother me as much as, like, drugs should be illegal, or there should be a patent or copyright system or something.
Right. That's very interesting. And for the most part, I think I agree with you. So that's good. Let me just now shift a little bit to the anti-IP law and how that. So, and again, I'll be very simplistic here because that's my nature. I'm not all that smart. Let's figure this out. So, libertarians are for individual property rights, but you're against intellectual property rights,
right?
So that on its face seems contradictory. For example, your new book that you held up before Legal Foundations of a Free Society. Does your anti-IP stance mean I could just plagiarize every word in that book, slap a different color cover on it, and sell it? Is that the position?
Hold a second. Yeah. It's so funny because I hear this slap analogy is used so often with this. It's like, oh, if you don't believe in IP, what if I just slap my name on your book and I make $1 million off of it? I'm like, well, first of all, if you can figure out a way to make $1 million off of a 800-page dense work with, 7,000 footnotes,
right,
be my guest. I'd like to learn. I'd like to peer over your shoulder and figure it out.
But do you see where that? I mean, it's a hack analogy, right?
No. It's just funny. But so let me. So yeah. and you said. So here's the thing. And you said plagiarize too.
Yes.
So the problem with intellectual property is it's, number one, it's a very arcane area of law. It's sort of like tax law or the Administrative Procedures Act. Most people don't really understand it. And there's like so many types of IP. I mean, I had to go to college and practice to learn this. That's why I was a specialist, right? But there's trademark, there's patent, there's copyright, there's trade secret, there's other things too. And then there are things like plagiarism. And these things are all different. And for me to go through a 2-hour lecture to explain them all would make people's eyes glaze over. But so plagiarism is simply meaning it's dishonest representation of your work as someone else's work. It's just not giving proper attribution or credit.
Okay.
That's what plagiarism is. It's not a crime. It's actually not illegal. It's just usually prohibited by social norms or by school codes or whatever. So, as an example, and by the way, my book has copyright Creative Commons 0 license on it.
Okay.
So I published it with CC0. There's a free PDF online, and I'm about to release a free EPUB. Even though I'm selling it also on Amazon Kindle and in paper. and so I have released my book from copyright as much as I can. So yes, under the current law and my license, you could take the text of my book and publish it tomorrow under the name Big John with the same title if you want to, and you would not be in trouble. And I wouldn't even give a shit. I don't care. But no one's going to, but you know what? You can do that with the Bible right now, or you can do that with Romeo and Juliet.
Right.
Those are not under copyright.
Right. I get that.
So why don't we go to Amazon right now and see 1,000 copies of Hamlet under different fake names? Why does that not happen? Because no one has the interest to do it, because no one's going to buy it. It's just not a real problem in the world.
Well, yes and no, right? And again, please indulge my simplicity here.
Sure.
So, for example, I'm a software developer.
Yeah.
Or I used to be in the past, right? So if I create a piece of software that serves a particular function and I sell it, am I entitled to, in your mind, to any protections from the law? Is that my property if I create a piece of software? Let's say, okay, so in your mind, I create Excel. Let's say I'm the first, or I created Lotus Notes back in the day, the first spreadsheet. It's helping, it was a hereto non-existent piece of software. It has a physical, it has a tangible sense to it.
No, it doesn't.
Sell it.
No, it doesn't have a tangible sense to it.
Oh, explain that to me. Okay, why
do you say it does? I mean, so you have a way of organizing information, right? How is that tangible or physical?
In that I can sell you the software. You can.
Okay. But now, if I buy software, I don't buy anything tangible. I just go to the App Store and I download some data, right?
Right. So, are you distinguishing that if it came on a CD or a floppy disk, or?
No, I'm saying that you can. In the emerging technological, in the way things were in the early 2000s or whatever, 1980s and 1990s, the only way to convey data to people was with a physical medium.
Right.
Just like the only way to sell someone a book would be to give them a piece of paper or a bunch of pieces of paper with ink on them, right? Patterned in a certain way. But the copyright people they don't claim they own that physical thing. In fact, that's what they're selling. So they don't own it anymore. If I sell you a book, or if I sell you a CD-ROM, or a magnetic tape, or whatever has this data in patterning on it, I'm selling you a physical item, but that's not the reason the people are paying this high price for it. They're not paying
correct
$50 or $100 for something that only costs you, 10 cents. Like they're buying because it has data on it that they can use. But nowadays they don't even need that. I mean, there's movie streaming and video music streaming. People just get data bits over the internet. They don't need the physical thing anymore. It's not really about the physical thing. So what I'm saying is you're claiming ownership of an patterning of information. So let me tell you how. Okay, so as a libertarian, my original view was I'm against aggression, bullying people.
Yes.
Okay, but when I thought about it more, you realize it boils down to property rights, because it's all about. Well, what's aggression? Like, if you see two people fighting, which one's the bad guy? It depends on their claim, right?
Yeah.
Or if two people fighting over, I don't know, an iPad in the street, maybe the guy that's winning the fight is the good guy because he's getting his iPad back. I don't know. It's like, so it depends upon property rights. Everything goes back to property rights. And to me, property rights are basically a social mechanism we have discovered as a social species as a way to resolve disputes and to let us live peacefully with each other in the face of possible conflict. Conflict is only possible over scarce resources, things that you can physically employ as part of your daily activities that you could fight over.
Right.
So that's the whole purpose of what rights are and property rights and law. It's always to try to reduce conflict by assigning an owner to a thing. How do we assign ownership rights? One way to do it would be by arbitrary verbal decree. Like, I'm bigger than you. I'm white and you're black, and therefore I have better rights than you. Okay, those are not good reasons.
Correct.
So the good reasons are fair reasons that every rational person could agree to and move on and live with the situation, which is basically, okay, we all live in a world of these resources that are out there that God gave to the world, but they need to be used for us to live. So people need to be able to use them, which means someone needs to use the thing first. So there needs to be the ability to use something first. That's called homesteading or original appropriation. So in other words, the property rights rules that have to underpin any just, workable, fair legal system that everyone can mostly agree to would be based upon the private law principles that have always been here for thousands of years, which is everyone owns their own body, presumptively. Like, you can't use my body without my permission. I can't use yours. Leave me the hell alone, right?
Right.
That's self-ownership, you can call it. Number two, if I'm the first guy that comes across something unowned in the virgin land, I can use it, and no one can object because they're not the owner, but because they didn't use it first. But then if we want me to be able to use this for a long period of time, to have capital production projects and things like this, I need to have the owner of it, in the sense that no one else can just take it from me because they came second and they just are bigger, stronger than me.
You have to be recognized as the owner.
Yeah. So basically, you're recognized by establishing a connection to a thing. Your body is obvious because you're the controller of your body, so that's already obvious. But for other things, it's basically homesteading and contract. So, or if I give it to you, now you're the owner. So, like, that's the core of all Western law, is like self-ownership, homesteading, and contract. And then maybe a third thing, which is called rectification or restitution. Well, if I do something wrong to you, if I hurt you, if I invade your property, if I use your stuff without your permission, to make it up to you, I have to give you something to make it up to you. Like, I got to pay you some money. Like, so that's the third way. But basically, that's the whole of all law. Law is just working out the details of all this. Right. Once you understand that, you will see that in this story, nowhere did the concept of creation come into it, which is implicit in your idea that if you call something property and it's something that you created with your mental labor or your mental effort that's valuable to other people. See, there's so many assumptions in this formulation. The assumption you're kind of implicitly relying on is, number one, if something is called property, then it should be a property right. That's obviously stupid, right? Just because the government calls patent and copyright intellectual property, which they didn't do in the beginning, by the way. They were called intellectual privileges. And then when the free market economists in the 1800s started revolting against this and almost got the entire international patent system repealed because they realized it was a violation of property rights, then the vested interest started calling it, they said, no, it's a property right. It's not a privilege. They just called it that. So that's one thing. The other thing is the assuming that something has value, that it's property. And the other one is the assumption that if you can sell something, that it's property. And I have a whole chapter debunking that confusion in my book. And this is where it gets complicated, because you have to distinguish between the economic or the descriptive realm and the prescriptive or the normative or the moral realm, because we use words like sell or own in different contexts differently. This is why I said earlier, it's important to be precise in language. So if I sell you, let's say I sell you my program for Excel or a spreadsheet. Right. That sentence is just a way of describing the praxeological or the means in structure of what we're doing. It's a way of describing why I did what I did and why you did what you did. What I did was I performed an action that satisfied you. I gave you some information somehow, right? That's what you wanted. Right. I did it because my goal was to get your money. Okay? What you did was you gave me some of your money in order to induce me to give you information. So like, it's just a way. So when we say sell in that sense, it's an economic description. Legally, the law is totally confused on this, which is why I try to clarify it with the Rothbardian title transfer theory of contract, which is chapter 9 of my book. The entire so legally, in the case of me selling you a program for you paying me money, I think economically that description is fine. But legally, what really happened is you gave me your money conditionally. You said, I will give you this $100 if you perform a certain action that pleases me. Basically, right. That's what happened. It doesn't mean that you own my action or that I owned my action. Or the action was legally sold, because it's not like there was an action in a jar and there was title to it and I gave you title to that action in the jar. It's like, it just doesn't make any sense. Does that make sense?
I understand what you're saying. I'm not sure that I agree with it. And maybe I'm just not using the right words, or I'm not processing what you're saying correctly, because let me give you a concrete example and perhaps you can tell me a little bit about it in your framework, which is, I work for a big company, and this is an actual case. I discovered a methodology, a database methodology for resolving a particular error state.
Okay.
That ended up saving the company X number of dollars a year, very profitable for them. They've moved to patent it and keep it as a trade secret, right? So
no, you can't have both. It's one or the other.
They moved to patent it. I apologize.
Yeah.
They moved to patent it. So part of my employment contract was that anything that I discover that's of value while working for the company, the patent rights go to the company. So I willingly understood that, and fair enough. Is that methodology that I created, is it something that I owned, in your view? That specific methodology to resolve that particular issue?
Okay, so under the current law in America, the way to analyze it would be that you are the inventor of an invention. And the invention is, in this case, a process or a method.
Right.
Okay? Because it's probably within Section 101 about things that can be patented. It's a useful method or process. I assume it's non-obvious and novel, like no one's ever done this before. Okay. That's what qualifies you to apply for a patent. Under the current law, that's viewed as a property right. Certainly, the ownership of a patentable invention is a property right. The way the default law in most states works, and by the way, even if you had not signed an agreement, it would still be the same. That's the way the default law is called the work for hire doctrine. So if you're an employee of a corporation, and within the scope of your duties as an employee is to not discover, but to invent useful techniques and things like this, then by default law, then the employer is now the owner of it, and probably you had a written agreement to make that clear. And by the way, this is another myth. Everyone says, so if you're against patents, you're against the little guy. Like you think the big guy should screw the little guy. Which is another weird formulation you'll hear all the time. It's like, first of all, when did we become about being in favor of what does the little guy even mean? It's like, if you mean individual, that's okay. Okay. But on the other, it's like, there's nothing wrong with corporations or capitalism or companies. Right. And if you make an agreement on the free market, what the hell? It's like,
yes.
But second of all, if you really are in favor of the little guy, do you understand that most popular singers, like who use copyright, and most inventors, they work for corporations. Their IP rights go to the big corporations.
Right.
Don't you remember when Prince literally shaved or put the word
tattoo?
He put slave on his face because he was trapped for 15 years by one of his copyright. It's copyright and patent are not for the little guys; they're for the big guys. They cause cartels. They empower big corporations.
Right.
So I'm not saying I'm against big corporations and I'm for the little guy, but it's like the arguments for this thing make no sense.
No, what I meant was, while I appreciate that you said, okay, there was nothing shady or illegal, which I never claimed, but I'm asking you in your philosophical construct.
Right. Yeah. So I derailed myself. So legally, there's an invention that you are the presumptive owner of, except if you're an employee, then the presumptive equity owner is the corporation, and then your agreement even makes that clear. So there is a piece of property called a patent or a patent application in the beginning, and you're the owner, but immediately your rights are transferred to your employer. Okay, so they're the owner of that property, that method, and then they can use it however they see fit. They can sit on it, put it in their war chest. They can use it to sue people. They can use it to as collateral to get equity or to get a loan. You can do whatever they want with it. In my system, there would be no patent law, and there would no doubt be other mechanisms companies would come up with to handle these issues. There would be certainly far more reliance upon trade secret. So trade secret used to be, you mentioned they're going to have a patent and a trade secret. So this is the whole point. There used to only be trade secret, which means you can just keep something secret. You can keep secret your favorite sexual position. You know what I mean?
Like the formula for Coca-Cola.
Yeah, except even that is I think you could probably Google it and find it right now. It's probably online.
Okay.
So,
but like in popular culture, that was considered one of the greatest trade secrets.
That's a classic
ever, right?
example.
Yeah.
And the reason people would use trade secrets was for two reasons. Well, number one is a trade secret can last forever, theoretically. And also, but a patent expires after 17 years. So in a patent, the condition is instead of doing a trade secret, you're going to tell the government registration office through this document called the patent application, the specification, exactly everything everyone needs to know to replicate this in 17 years when it becomes public domain. Right. So you get 17 years monopoly, and then it becomes free. So that's the trade. It's called that's what the patent that's called this patent bargain. The patent bargain is that the government will give you 17 years of exclusive rights in exchange for you disclosing it. And the information you disclose can be used immediately, but they just can't copy you until 17 years is up. So that's the bargain, right? So the risk is that if you keep it as a trade secret, which you could do potentially forever, if someone else independently invents the same thing you're doing, like a chemical mixing method or something. So for example, let's say you're DuPont and you have your engineers come up with a way to mix gasoline and something in a more efficient way. You don't really have a good way to sell that as a product anyway. What you're selling is an improved gasoline to people, but that's not patented. It's just, but the way you mix it is with this nozzle. Right. So if you patent it, you tell all your competitors how to do it. They can't do it for 17 years, but you're telling them. And so eventually they're going to be able to compete with you. Just like when drugs come off of...
I was going to say the pharmaceutical industry might be a better example.
It's very similar. But the point is, if you keep it secret, theoretically that could last you for 50 years. Or 100 years.
Now, is a trade secret a legal designation?
Okay, let me get to that. So the point is, the danger of the trade secrets under the old law before Obama made a few changes, but the danger is that your competitor might come up independently with the same invention, and then they might patent it, and then they can stop you from using something you've been doing for 40 years.
Right.
Now, there is something under the Obama America Invents Act, which gives what's called a prior user right. So there's a limited defense now in that case, but the whole thing is arcane bullshit. But the point was, this is again the difference between law and description and facts and norms and reality. A trade secret is just something you keep secret. Just like you might keep secret what your favorite movie is. I don't know. Right. You can keep any, but there's no law that says Big John has a right to keep his memories secret. It's just the fact of the way you use your body, right? That's encompassed in the fact that you have bodily, there's no slavery. That's effectively the consequence of it, right?
Right.
what trade secret law, and I think trade secret law should be abolished as well. I don't think trade secrets should be abolished. People should be able to keep secrets. But trade secret law, what trade secret law says is that if I have an employee and my employee, and I have diligence in keeping some information secret that helps my company in competition with other people, right? Gives me a competitive advantage. If I have that kind of knowledge that's not publicly widely known, then if I've made diligent steps to keep it secret, like by having non-disclosure agreements with my employees and things like that, then if my employee runs off and joins a competing firm and tells them my secret, I can get an injunction from the court, not only against the employee,
against your competitor, right?
which I could understand because he has a contract with me. I could understand an argument for an injunction against him or for damages against him. Like you could sue him for damages because he had signed a contract and he violated this. But you can get an injunction against the competitor and say, you guys cannot use this information. Now, if it becomes widely known, then it's not a secret anymore and all bets are off. And that's the problem with trade secret law. I mean, look, this is not the same thing, but like I mentioned this many times before. In copyright law, one of the Harry Potter novels, I don't know, number 5 or something, they were shipped to these stores. They shipped them before the official release date, right? So this bookshop in Canada got like a couple of crates of this Harry Potter number 5 or something. And they accidentally sold them 2 weeks ahead of time.
Right.
So they sold hundreds of copies of a Harry Potter novel. And of course the publisher went apeshit and they went to a court in Canada and for emergency injunctive relief. And this court issued an order to all the customers who had bought. So these customers walked into a bookshop, they buy a book, they go home with it. They're Harry Potter fans probably, right?
Right.
Half of them are probably reading the book the first night, right? They get an order from the court saying, we're hereby ordering you not to read the book and not to tell anyone about it until its official publication date, because otherwise you're violating copyright law. This is how IP law works. IP law is always an infringement upon. But let me get back to one point you mentioned earlier, this creation thing. The reason I mentioned creation is that let me try to explain it, and you tell me if this makes sense.
Sure.
This is the way I've come to understand this in my myriad of interviews with people and people who are usually promoting IP. So you create this spreadsheet idea or something, right? Either as an employee or on your own or whatever. And the idea is, well, then why don't I own it? Why isn't it property, right? But you'll notice again, the basic property rights of the Western legal system is you own your body. You didn't create your body, right? You own it because you control it. Because you are yourself. That's why you own yourself. It's not because you created anything, right? And if I find a tree in the forest and I bring it home and I make a table out of it, I didn't create the tree either, did I?
No.
And if I buy some wood from you as a contract and I get the wood and then I make a table out of it, again, I didn't create. The reason that I own the table is not because I created it. I already own I already own the wood. I own the wood because I found it and it was unowned, or because I bought it from someone by contract. Neither one of those has anything to do with creation. So creation really has nothing to do with ownership. What creation has to do with is wealth. And what wealth is the availability of scarce means in our lives that help us to achieve the ends that we have, right? So for example, if I turn this hunk of wood into a table, I've increased my wealth because now I have a table that I can use, or I can sell it to someone on the free market and get money from it. So like in either case, I've increased my wealth by my labor, by my intellectual effort. I totally agree with that. So creation is a source of wealth, but creation is not a source of ownership. And that's important to understand. And because if you don't understand that, you're going to be a Marxist or a commie. I mean, this is why communists say that any worker of a firm that makes a profit is being robbed, because they think that the workers created the goods that are being sold. And if there is a profit, that means that there's a surplus, some of their labor. They think that the value of these goods is because of the labor that was put into it. They think of labor as a substance or a thing that's ownable, and that is being stolen from them by the capitalist, by the employer. This is the fundamental mistake. Creation is not a source of ownership. It's simply not. If it was, the worker on Henry Ford's assembly line is the creator of the cars. Why doesn't he get his fair share of the cars?
Well, I would argue that his employment contract prevents that.
I totally agree. But then but a contract is only the working out of property rights. A contract is simply the decision of the owner of a resource about what to do with their stuff. I mean, you could say if I kiss a girl on a date, the reason it's not a battery or rape, it's because she consented, because she owns her body, right? Or if I let you come into my house, or if I rent you my car, it's because I own the car. That's what contracts are, just an implication of property rights. So we have to first have an idea of what property rights are. And so the reason that I totally agree with you, but the left libertarians would say something like, well, they ultimately don't believe in contracts, and they ultimately don't believe in property rights, because if you don't believe in contracts, you don't believe in property rights, because a contract is just what the owner does. So, for example, a left libertarian might say that a mutualist might say that, well, if I own an apartment complex in another state, then the people living there are the real owners. Or if I have a factory making widgets, the workers are really the owners, because they're the actual possessors. Even though I had a contract with them saying, I'm going to let you live in my apartment complex, but you admit that I'm still the owner, right? And you got to pay me rent. Or right. I'm going to let you work in my factory, but you agree that I own the factory, and you're making stuff for me. They ultimately, if you're a mutualist and you think that absentee ownership is not permitted, you ultimately cannot. That's because you disregard the ability of people to have property rights and to make contracts with their property.
Right. I see that, actually. And it's interesting because, and I don't want to, this is fascinating. I could talk for hours, but I know you don't have hours. So I want to see if I can wrap it up. So a statement that's always fascinated me is mathematics discovered or created? Right. I don't know if you've ever heard that phrase. But it's this concept, like, is math something out there in nature and we're just taking our turn chipping away the way you would dig for gold to find these nuggets of mathematical knowledge? Or do we invent math? What is the square root of 2, right? It's an irrational number by definition, right? But there's whole constructs, there's whole philosophies that work, that function in the real world based on these mathematical discoveries or creations, depending on your point of view. Could not you say, I own something and to some extent created it intellectually because I've figured out something that no one else has to this point, whether it's a process or a new set theory, whatever. Like, I think I'm getting hung up on that particular definition of property rights, and maybe I'm not seeing it as clearly as you're explaining it, but that's the hang up to me. Like, I understand, and I understand if you were to tell me why 17 years for a patent, why 99 years for a copyright, I would agree with you. I don't know why those numbers are what they are. They seem completely arbitrary to me. I acknowledge that with you, but to your point, that might be more the detail to work out as opposed to the first principle, right? So I kind of ignore that part of it. Like, why 17 years? Why not 25? Why not 5?
Well,
and
the reason I mentioned that is to explain why I initially started searching for my own solution. Like, okay,
fair enough.
And there are people that admit that it's arbitrary, and their solution is to say, okay, if my
Find
choice
a better
is
number.
if my choice is no, they say if my choice is 0 or infinity, I'm going to choose infinity.
Mm.
Now, for me, if my choice is 0 or infinity, I'm going to choose 0 because infinity is preposterous. I mean, imagine paying royalties to whoever invented fire.
Agreed.
Still,
I agree with that. Like, I don't know what the right number is, but I do agree it's not infinity. I also don't know that it's 0 either, and
correct.
maybe that's I
understand.
That's the point.
I understand, but to think that there is a number, you would think that someone would have tried in the last 240 years of this country to figure it out. And they just keep punting it away, and they keep increasing. Yeah. They keep increasing it due to legislative, everyone says, "Oh, it needs to be reformed. It needs to be shorter." It's like, okay, well then, what's your it's like the Laffer curve. You remember the Laffer curve idea? Yeah. By the way, I'm going to get back to your other question though. Your other question is interesting about discovery. So let me tell you my probably iconoclastic idea on this, perspective on this. There's a recent book. I'm trying to remember who it's by, like Pinker or one of these guys. Anyway, I forgot. But he tries to make this subtle distinction between invention and innovation. And to be honest, I mean, I'm a 30-year patent attorney. I'm an expert. I don't even know what I don't know. I can't even remember which. I think innovation maybe is like an idea that you come up with, but it's just like pie in the sky. No one can use it. An invention is maybe like a practical way to use it. Something like that. Like he tries to distinguish it. Similarly, in IP law theory and among people that talk about it, even Ayn Rand, if I recall, they have this distinction between discovery and creation or innovation, right? To me, it's an interesting thing to talk about as a grad school philosophy student in a dorm room with a bunch of kids smoking weed, I guess. I mean, did Einstein invent E equals MC squared, or did he just discover it? And by the way, he wasn't the first one to discover it. There was people before him that came up with it without his relativity nonsense. But those are interesting discussions to have. But I think that what happens is, because we have IP law, because there is copyright and attribution issues and patent law, these things get all mixed up, and people find it necessary to have an opinion on it. Like, well, like Ayn Rand says, well, you can't patent a discovery, obviously, but you can patent a creation. It's like, so now we have to have a classification or a legal distinction between discovery and creation. Whereas before it was more of like an academic or an intellectual discussion. Now it has legal impact. And so like as another example, quite often you'll hear some rock band accused of copying some other song. Like I think Led Zeppelin's been accused of this with Stairway to Heaven. Now, of course, their first reaction is to deny that they had any influence from this other band. I never even heard them. Now, why would they deny it? Because if they admit it, they're admitting copyright piracy, and they might be liable for millions of dollars, right?
Right.
Whereas, in my world of no copyright, I don't think people would. They would just say, yeah, I think I might have heard that. Maybe I got influenced. Like they wouldn't be afraid to admit the truth because there would be no liability for admitting the truth.
Yeah, I could see that. And listen, it's always a tricky subject, right? What have you been influenced by? What have you ripped off? Like even from an artistic point of view, right?
Yeah, but see, I hate that. So influenced by is fine. We're all influenced. And by the way, this is the other thing about creation. No one ever creates anything from nothing. If you create like a table, you got material from matter, and you happen to be born into a healthy body, and you could do that. If you create a song, you're of course influenced by all the cultural influences you've been brought up with in your life. But that's not a bad thing. That's a good thing. This is why we have society and culture. So I don't understand why people are so like guilty, like, oh yeah, maybe I heard this one time. It's like, there's nothing wrong with that at all. Right.
Yeah. I came into this discussion legitimately interested in hearing your position on this, because I'm fascinated by it, and it's not a traditional position. And again, even among libertarians, I think you might get a wide range of acceptance.
And
right?
let me say something. I just realized we had this whole talk. I don't think I've ever given. I never gave my. I mean, people can read my stuff, but I mean, I never really even went into the details about how I came against IP. But but it's interesting that. I will say this. Here's my impression, and I could be biased. My impression is that when I started writing on this in 1995 or so, that was the dawn of the internet, right?
Right.
I do think that most libertarians would probably loosely be pro-IP because Ayn Rand was, and because it's called property rights, and because it's in the Constitution. And patent and copyright have been part of the American capitalist system for 200 years, So I think there'd probably be a loose pro-IP inclination among most libertarians. Probably almost all I'd say 40 years ago, let's say.
Right.
But I do think that with my work and with the work of some others like Roderick Long and Jeff Tucker and others, I do think that it's different now. I think that among libertarians today, almost all Rothbardian anarchist libertarians, most left libertarians actually, are all anti-IP now. The ones that remain that are pro-IP are the utilitarians and the pragmatists and the Randians, the objectivists. That's my impression. I could be wrong, but that's kind of my loose impression. So in a way, I mean, my personal view, not being paid for this, is I think I'm gratified because I think I've made some influence, some effect on a significant number of libertarians. And I talk to people and they actually get it because they can repeat the arguments or they can apply them to new situations. So it's one case where I think reason actually works sometimes.
Sometimes.
I agree.
Sometimes.
You would think it would work with a drug war more easily, but
but it doesn't always.
With the normie. Sorry, but I didn't mean to interrupt you. But I realized I've forgotten to actually address that and give the actual argument against IP, which is basically that it's a type of. It violates property. My main argument is that it violates property rights and it can't be justified. It has negative consequences, but to me, that's a secondary thing. The utilitarian argument for IP has never been justified, but I think that's not the most essential way to look at it. Although you can look at it that way too. Like you said, everyone says, "Oh, if you don't have IP, you're not going to have enough invention or enough music or whatever." It's like, well, what's enough? And is it really the goal of government and the law and the state to pass laws to make sure that we have an optimal amount of invention and innovation and incentives and music and art and software programs and movies? Is that really the goal of law? And can the state really do that? So that's the utilitarian side of it. You know what I mean?
Right. Yeah. The only thing I agree with you generally, and I want to wrap it up because I know you're limited on time, but I would just say just like an experience with say pharmaceutical protections, that's an easy example, which again is the fault of the state, because they will tell you 17 years is not enough of a patent protection for them to recoup what they have to put in, not just in their own research and development, but the administrative state, like the regulation and everything. So by the time a drug hits the market, they're already 14, 15 years into their 17-year protection, right?
That's why there's exceptions built into the law to give them an extension of their patent term or an FDA type extension. Like they do all these things. And by the way, when you say recoup, see, that's the other thing. Their standard argument is like, well, how am I supposed to recoup my costs? It's like, well, again, like I said earlier, your failed business models. But the thing is, the costs they're trying to recoup are costs that were imposed by the government in the first place.
Yes. Yeah. Well, that's the catch-22. And I agree with you. It's not the government's role or anybody else's to figure out how you're going to make money. But I I would understand them saying, like, for example, if there is this protection, or no, I'm sorry, I meant I could see how it would go to the utilitarian argument of, would people be motivated to innovate just on a societal level? Would they be motivated to innovate and invent and go through this tedious process if there was no motivation for them to do it?
Correct, but then the question is it the goal of the law and the state and government to motivate people? I mean, you see,
no,
like that's
to motivate. No, to motivate. No, I agree with you. It's not their job to motivate. Is it their job to protect it if you consider it a piece of property? If I create the next now I'm drawing a blank on AbbVie's drug that's considered the most successful drug in the
How about the
history
next COVID vaccine? How about
the
that?
next COVID vaccine?
Oh yeah,
whatever,
let's have more COVID vaccines, please. We need more of those. That's a good example. By the way, that's a good example. Everyone, like, this is the one the one case where I might like be in favor of patent law, because patent law made the COVID vaccines more expensive, and
right.
I mean, usually I'm against that because it makes innovation and imitation less likely. But because I'm not a big fan of the COVID vaccines,
There you go.
This might be one case where the patent law did us a favor. Except what happened was we had to pay for it anyway.
Yes, we paid through it through the inflation that followed and the debt.
We had to pay for it anyway.
Yeah. Well, that seems a good way to end it right now. So I want to thank you for that. But before we do, Stephan, thank you for that conversation. It was very interesting. But I want to get to the part of the show to wrap up called Silly Questions. And these are 5 questions I'm going to give you. There's no right or wrong answer. I just want to ask you this to give the viewers a little bit more a sense about Stephan Kinsella. So, number 1, what is your favorite dessert? Assuming that you never had to worry about your waistline or any other health concerns, what's your favorite dessert?
Banana pudding.
Banana pudding. Very interesting. That's a Southern thing, is it not?
Yeah, probably.
It probably is. Okay. What's the funniest lawyer joke you've ever heard?
I don't know. Maybe there's one about like well, there's one that's like how can you tell when a lawyer's lying? His lips are moving.
Right.
But no, the other one is like something like there's a bus that goes off a cliff and there was 99 lawyers and 1 seat missing. What do you call that? A crying shame or something? But
tragedy, right?
Yeah,
because there was one empty. Okay, great. If you could attend a lecture by any person, alive or dead, whose lecture would you attend?
Mises.
Fair enough. If you had to create a parody song about intellectual property, which tune would you choose to parody? So you're like a weird...
Probably Limelight by Rush.
Oh, okay. There you go. Limelight by Rush. And finally, the bigger threat to innovation, patent trolls or a state-run education?
State-run education.
Oh, I thought I might have you there on that one.
No, because you didn't say patent owners. You said patent trolls. I think patent trolls are a minor part of the problem of the patent system. So that's the state, of course, the state.
The state-run education.
Yeah.
All right, great. Stephan Kinsella, thank you very much for joining us here on The Big Question with Big John. Please let everyone know your social handles and where they can find your new book.
I'm NS Kinsella on Twitter, and I'm StephanKinsella.com, where my book can be found.
Okay, and that book is what's the title again? From the
Legal Foundations of a Free Society. It's on Amazon.
Legal Foundations of a Free Society.